Welcome to the Privacy Filter, Barnes& Thornburg's briefing on privacy law and policy. Subscribe for the latest updates.
All right. Hey, thanks for joining. This is Brian McGinnis. This is the Decrypted, the Privacy Series video podcast from Barnes& Thornburg. Again, my name is Brian McGinnis. I'm a partner here at Barnes & Thornburg. I head our data security and privacy practice group, practice in the areas of privacy, data protection, intellectual property, AI, and really all things technology-based. And I'm joined again today by Lyric. Lyric, would you like to introduce yourself?
Always. Thanks for having me back, Brian. This is always a fun conversation to have. And for those who don't know me, I am Lyric. I am an associate in our Los Angeles office. I work with Brian every single day, and my practice revolves around all things intellectual property, data privacy and security, and technology law generally. And I'm really excited to delve into AI today.
Yeah, so this is part of our series. We're kind of wrapping up 2025 with a look ahead to 2026. We've got an episode with respect to new data protection and privacy laws that are coming out in the US over the course of the next year. So be sure to check that one out. We'll do another one here on the California Invasion of Privacy Act, SIPA. But today we're going to delve in on the Colorado and California AI laws and get into a little bit more detail about these, first in the country laws that are really leading the way when it comes to the regulation of the use and deployment of AI in the US. So, Lyric, I'll kick it back over to you. Where would you like to start?
I think the best place to start would be to give a plain English sort of data privacy for dummies overview of what Colorado's AI Act and California's automated decision making rules actually cover.
Yeah, probably a good place to start at the start. Right. So there's this thing called AI. You may have heard of it. It's getting kind of popular these days. Every piece of software that's out there seems to be AI software now, whether that's actually a significant part of the business or not. We're seeing this all over the place, and the clients that we work with are as well. So it's kind of as a first element, hard to even decipher what it is we're talking about when we say the words AI. But hopefully or thankfully, we've got some new laws that are coming along to help us put some more structure around what the legal regiment's going to look like here. So, coming up in a privacy background, I look at the parallels that I see very regularly between the privacy legal patchwork situation that we have in this country and what we're seeing in the AI world as well. So much like with GDPR in the European Union, we've got the EU AI Act that was really and still is sort of the gold standard and early AI regulation, obviously applicable in Europe, that really started to put some rules and some laws around this new technology. Obviously, the tech is always going to be ahead of the laws, but we're just in the early days here of getting these things spun up that are going to regulate both the use and deployment of AI systems. In the US, the CCPA on the privacy side of US AI laws came from Colorado. So we've got the Colorado AI Act. And then another important law that's come around is through the CCPA regulations and California's regulation of ADMT, or automated decision making technology. So to start with the Colorado AI Act, this law, much like the EU AI Act, regulates what it calls high risk AI systems. So in other words, this isn't a regulation about the AI chatbot on a little product page or internal customer service or anything along those lines. The goal of the law is to regulate against things that it deems to be high risk. So these are tools that make or kind of help make important decisions about people's lives. So in other words, if it's something that can change your life, that's potentially a high risk system that needs to be looked at and considered whether or not it's something that's covered under the Colorado AI Act. Things like whether or not an individual is going to receive a job as part of an application at your organization, if they can get a loan, if they can get an apartment, school placement, healthcare decisions, insurance, legal services, et cetera. Any of these kind of consequential decisions across areas like employment, education, finance, housing, et cetera, essential services, those are potentially high risk AI systems. If it is a highest risk AI system, it's regulated by the act. If it's not, may not be. Interestingly, too, I think Colorado AI Act divides the world into deployers of AI. So those are the companies, the organizations that are utilizing the tool, and then the developers are obviously those who have developed or built out these tools. And it puts duties on both sides of them. And those duties include running risk programs. In other words, if we are deploying or developing these high risk AI systems, what are what is a risk of running these programs? What do we need to consider? What if something goes wrong? The way that they want us to do that is through what they call impact assessments, or IAs, that are similar to a DPIA or a PIA, a privacy impact assessment, that allows the organizations to document how the system works, what monitoring they have, what kind of care they're taking to make sure that there aren't, things like biases or discrimination or unwanted outcomes out of turning these AI systems loose. So you'll often hear the phrase "human in the loop," meaning having some kind of human oversight over the use and deployment of these systems to make sure that somebody's got eyes on the way these are being used. All these things are required for these high risk AI systems in Colorado. So interesting in this year, two in-house counsels is that the law has been passed and enforcement begins June 30th, 2026, and that's Colorado. So, Lyric, I don't know, before I go into California, if you had any questions specifically about Colorado, or do you want me to go through California as well?
Well, you touched on something I was going to ask you about key dates because, as you know, I live and breathe by my calendar and my organization systems. So you mentioned June 30th for Colorado. Are there any other key dates or timelines that clients should literally have on their calendars and preparing for these before we turn to California?
Yeah, well, that's a great segue to California, actually, I think, because the core obligations there are going to start January 1st and require some additional audit and risk assessment requirements later on in the year. So maybe let's just go through that quickly and then we can talk more about kind of the rollout of the laws. But I guess taking it back to the privacy analogy, the California CCPA, now California, the regulations as part of the law are rolling out these automated decision making technologies, ADMT system regulations. So these are systems that use techniques like machine learning, advanced analytics to evaluate personal information to help make some kind of critical decision. Again, think about areas like employment, credit, housing, education, all the kinds of things that Colorado is looking to regulate for the most part.
What about legal stuff? Is that also considered high risk?
It can be. I think you have to look at the context in which the AI systems are being deployed, right? So again, anything that can make an impact on somebody's life or a decision about them, I guess the underlying thesis here is we don't want to turn that over entirely to what is ultimately math with these machines and the AI tools. So making sure that there is some kind of human oversight and interaction within the laws, I think is critical. But the ADMT laws have a little bit of different language than does the Colorado AI Act. It talks about significant decisions, but I think getting into similar areas. So, a question that we get all the time is, okay, we're dealing with these two laws today. What do we have to do for the future? We don't want to have to, continue to change our program every 3 months. And really, taking keys from the through lines between these two laws. And if this plays out anything along the lines of the privacy space, you're going to see these kinds of principles get pushed forward within additional state laws, if that's even possible. I know there's some conversation at the federal administration level with the current president with respect to really making sure that we don't have too many restrictions on AI systems brought by the states. And there's been discussions about potentially outlawing any states from passing laws that would restrict. But whatever regulations do come, whether that's in the EU, in the US at the federal level, or the state law, I think you can be certain that the primary target of those laws is really going to be trying to protect individuals, protect people from having unfair decisions or discriminatory decisions or anything on those lines made about them simply because people are kind of turning over to their decision making to AI tools, and having some regulations to hopefully make sure that those kinds of things don't happen, or at least happen a lot less. So within the ADMT laws, you've got requirements like pre-use notice to give consumers a heads up that AI tools are being in use. As part of whatever process they're going through, or whatever software they're using, there's opportunities to opt out of that or elect an alternative process that doesn't require AI. All those kinds of things are really at the forefront for any kind of AI regulation I expect to see in the future. Like we talked about, though, those core obligations are going into effect here in a couple weeks, January 1st, and then we'll have additional requirements built out over the course of the next year. But even though these are state laws, I think it's also important to realize, again, like we saw in the privacy space, it's really hard at a certain point, and maybe two laws isn't it, but it's not too far away from there to segregate out people who are in other jurisdictions and say, well, we don't have to worry about this because we don't have headquarters in Colorado or California, for example. These laws very quickly will touch, if not your organization directly, certainly the partners and vendors and those kinds of things that you work with. So really understanding that these are coming and making sure that these are part of your overall governance program is really critical as we step into 2026.
I agree with that absolutely. And we've talked a lot about what is risk. And that was the basis of my question when I asked about, well, what about legal services? And so I think a good question to ask here would be, how do you separate what is a nice to have AI tool from what is truly a high risk system that needs the most attention? And I know you've mentioned core elements that impact everyone's lives, like whether or not they get a job, financial information, healthcare information. But what is the true separation? Where do you draw the line between nice versus risky?
Yeah, I think it's a case by case scenario. I don't know if you have different thoughts and would welcome to hear them, but I think ultimately, it's important to understand these are, at the end of the day, consumer protection laws that are meant to help protect individuals and help put requirements on businesses and organizations who are using these tools to be upfront about the way that they're getting used and the outcomes of those. So I think we could create all sorts of hypotheticals on either side that are either in or out. Interesting law school exams coming soon on these things, I think. But yeah, I think at the end of the day, if you're doing an assessment of what is this tool for? What are we trying to do with this? Are we using AI because it's, a cool word to say and it's hot? Maybe it drives some sales, not necessarily bad, but you probably shouldn't be doing anything that's even getting close to that line of high risk or significant usage with those kinds of systems. Or are we making decisions that can really have a potentially negative impact on people? And I think the biggest thing here is an unfair negative impact on individuals. If the use of the tool is just a shorthand way to get out from doing the work, and the result of that is, discriminatory behavior or unfair hiring practices, et cetera. All the other laws that we have preventing against those kinds of things don't go away simply because we're talking about an AI context. So making sure that you're staying on the right side of those and the meaning of those laws and the purpose of those laws, and just applying a new tool, in this case AI, to how you make those decisions is important. But what do you think?
I'd agree with that. I think that one way I would categorize high risk versus nice to have is essentially if it's just adding low impact personalization. For example, if I'm in a really frustrated mood and I feel like the tone of my email is much too harsh for the situation, maybe using the assistance of AI to rephrase that versus actually drafting that email and sending it without any oversight or governance from me if it's for something that is one of those high risk scenarios. And you mentioned assessments, and I think that these sort of templates for pros and cons, risks and benefits, data sources, accuracy, bias metrics, and all of that is also really important. But ultimately, I think that as a lawyer's favorite phrase is, it depends on the specific use case. On that basis, I wanted to sort of turn to the last part about this, which is what does an effective AI governance committee actually look like inside of a company? Because this is still so new. And I think it's important to discuss who's at the table and what authority do they need and what authority do they have at this point.
Yeah. I was just going to say, I wouldn't want my defense lawyer in a criminal case, for example, writing briefs using AI or those kinds of things. But yeah, I mean, I think privacy law has been around for quite a while at this point, and we still have, any number of clients that don't have internal staff and dedicated resources towards privacy consideration. You've got people, maybe it's part of their job, but I think I don't know what the exact numbers are, but I would venture a guess that most companies don't have a chief privacy officer or privacy appointed individuals or people with CIPP certifications or things like that that are tasked with running these programs. So When you're talking about the advent of AI laws and really the rollout for the first time, I expect that is even less. In terms of what the team needs to look like, again, similar with privacy, you've got some companies that are going to tackle this purely as a technical problem, meaning, the CEO is going to defer to the IT guy about all the technology stuff, or the marketing people about the uses, or the sales team about all the cool things they can do with AI from a technical standpoint, from a tool standpoint, without really getting into the legal side in terms of what compliance efforts are required of them. So I think it's key to have people from across the organization, different departments, certainly IT and technology teams need to be part of that, but so do the marketing team, so do the HR teams, sales teams, leadership, and having some kind of a cross departmental functional group of folks who can get together and talk about not only what tools are available to us, which I think tends to drive too many purchase decisions, but where are these things going? What do we actually need as an organization? And if we're going to take them on, how do we live up to the responsibility that the law requires of us to make sure that people are protected in our use of these tools? Again, this becomes more critical the more sensitive or the highly critical the use is of the AI system.
That makes a lot of sense to me. And because these rules are constantly evolving as new technology comes out, as of right now, especially through the lens of Colorado and California, what are the most important new questions or contract terms that in house counsel and clients should be focusing on when it comes to these AI tools?
That's a good question, and that's one that drives a lot of work for us right now with clients. Is we've got these agreements. Maybe it's a renewal of an agreement. Now all of a sudden there's a AI addendum on it, or AI terms that have been added, et cetera. You see a lot of questions related to intellectual property, who owns what, both on the input into the AI and the output of the AI system. Those are critical questions. Those of us that are old enough to remember social media law back when that was a thing, when sites like Twitter and services like Twitter were just getting started. A lot of the work to this point, or the legal consideration to this point in the AI space, has really been the application of prior existing laws like intellectual property to a new technology. And so all of those things are still going to apply, right? But the biggest thing I would say that we deal with AI agreements is ownership. And ownership and training, right? So I'm going to give you this data. I own it currently. I want to make sure that I own it after the fact. I don't want to transfer any ownership to you. We want to run it through your platform, through your system, but you don't get the rights to do anything beyond servicing us. You don't get the rights to train your AI system on that data. Those can be really complicated questions that need to be worked out at the contracting stage. Intellectual property rights that come out of that are also a big consideration as well. And intellectual property rights in the sense of, if you're building or deploying a tool, do you have the rights to content that you don't have otherwise copyrights to, in order to train and update and improve the AI system that you're deploying? Those are all interesting questions. But any vendor, any service that's providing these kinds of things should have these as part of their agreements, and you need to make sure you understand what they are before you go into a system. One last thing I'll throw in there too is open system versus closed, in terms of ownership of those. So if it's a closed system, ideally your information does just stay within your instance and your use, and it doesn't go into the model. It doesn't get used for training, and nobody else is ever going to see it, versus like a public open system of ChatGPT or any other system. Potentially there's some additional risks there.
Great. Well, Brian, thanks again for your time. And as always, this was a blast. And I look forward to being back for the next episode.
Yeah, it's always good to talk AI. I think people get sick of hearing about it, but it's really obviously interesting from a technology standpoint. But I think we're still very early days in these laws rolling out, and even considerations and conversations about how we're going to regulate and govern AI in this country, or if we are. The other side, the technology argument, is the more restrictions you put on this, the greater danger there is that we're going to fall behind others who are building these and getting the benefits that they promise. So it'll be interesting to watch as we go into 2026 for the next year, how those decisions start to get made, and where we end up landing on these things. Is Colorado and California style regulation of these systems going to become the norm? Or is the federal government going to step in and prevent those kinds of things from rolling out? In which case, where does that leave individuals, consumers? Do organizations like the FTC step up and try and protect consumers against impermissible or bad uses of AI. A lot to look ahead to, but I can promise anybody who thinks that AI is something that is only coming in the future, that's not the case. As we talked about with the enactment date and the enforcement dates of these laws, this is something that is here now that we need to worry about and need to get our arms around. So getting started sooner rather than later, I think, is the strategy here. So Lyric, thanks again for the time and for joining, and appreciate walking through this with you. Like I said, we've got the comprehensive privacy law rollout. You can go check that episode out, as well as if you're one of the unlucky recipients of a SIPA, California Invasion of Privacy Act lawsuit or arbitration request demand, then check that out as well. But for all of you that are still with us, we appreciate you joining. Thank you. And thanks again, Larry.